I don't honestly care if you're tired. I don't care about anyone's dinner reservation. I don't care if you made plans that afternoon. I care about finding out the facts. I care about justice. I care about a fair trial and understanding what happened to John O'Keefe. Hank Brennan is seeking new evidence and a new witness in his fair and unbiased prosecution of Karen Read. But with this new information and past statements, how fair is this actually going to be? Plus, we have a major player stepping in with some common sense on Karen Read's behalf. That can't be ignored. So welcome to The Point. Let's get to it.
Copyright disclaimer under Section 107 of the Copyright Act 1976. Allowance is made for fair use for purposes such as criticism, comment, news reporting, scholarship, and research. Fair use is a use permitted by copyright statute that might otherwise be infringing. Nonprofit, educational, or personal use tips the balance in favor of fair use.
Yes, I have something and I'm on more meds than a racing horse. But I can't just sit out of this fight. And everything said here is alleged. Please do your own research and form your own opinion. And let me know that opinion because this is an open discussion channel. And we're fair here. So if more fair coverage in this story and others is something you're missing, subscribe to this channel and hit that like button down below. Because on the surface, I thought Hank Brennan could be good for transparency. And he may very well be doing some things that are less shady. But how can he be the fresh set of eyes to ensure Karen's rights are upheld as a defendant on one hand while at the same time be without compromise? Honestly, make that make sense. I'm not making the case that all lawyers are evil or bad. I'm sure there's more than enough that are completely decent inside and outside the courtroom. But they are highly competitive. Make no mistake about it. When they are on the record, they want one thing and one thing only, and that's to win. That applies to both criminal defense attorneys and prosecutors. And what other reason would a high-priced criminal defense attorney take a case for so cheap, if not for fame, notoriety, or political favor? If you see it differently, please let me know down below, because I'm open to being wrong. But a lot of people think I'm on this channel advocating for the guilty to walk, when I'm simply advocating for the rights of every American citizen. Absolutely the guilty should pay, but jealousy or malice leads to vengeance. And vengeance has no place in our courtroom, our political offices, or the mainstream media. The guilty will only pay for their crimes through a fair and unbiased trial, where their rights are upheld. And I also believe, and you can correct me if I'm wrong, but actions speak louder than words, right? And the actions of Hank Brennan in these newest filings may provide us some insight, because the prosecutors are now seeking the phone records of William Read, Karen Read's father. And believe it or not, the state plans on calling him as a witness. But not only do they want the records between January 29th and the 30th, the time of the alleged crime, they are also seeking the phone records going back to December 30th of the previous year. The prosecutors are claiming Read called several people that night, giving conflicting accounts of what happened. And honestly, I believe it, because the vast majority of the state's witnesses did the same. I mean, it doesn't take a genius to know when your witnesses are out getting sauced the night before, it's going to cause a hectic crime scene. It's going to cause conflicting reports, which is why we heard testimony saying, I hit him, I may have hit him, and the snowplow hit him. But Brennan is essentially, on paper, wanting to prove that Karen Read doesn't normally call her dad this frequent. But I got a better guess as to why he wants those messages. And don't say this is the same thing as the defense getting Proctor's messages, because it's not. We had a lot of shady police behavior in this investigation. So much so the people of Canton, Norfolk, and Massachusetts have been up in arms about it. And it's not like those people have a history of being irrational. So there is some truth to that statement. And to be honest, the number of phones that have magically disappeared during this investigation is absurd. Now, I agreed with Judge Bev when she said the defense can't go on a fishing expedition related to this possible police cover-up, because the state has rights too. And we're fair here, and we back up everybody's rights on this channel. But Hank Brennan is very much going on a fishing expedition right now, in my own unprofessional opinion. and I hope this motion is denied, and here's why. To me, the burden of proof to establish that Karen Read was calling everybody and saying all kinds of things is already met. It's already been established. And a lot like Lally, spending an enormous amount of time of the trial talking to experts about the weather, it's honestly redundant. We get it. It snowed outside. There was a blizzard. Karen Read was frantic. It's been established. So why does he want William Read's calls and texts? Oh, that feels so good. Ask yourself that question and think about it. To me, it's obvious why he would want the calls and text messages between a father and a daughter. He's looking for that one golden statement they couldn't prove at trial. I hit him, or I think I hit him, plus any communication he can use to prove that Karen Read and John O'Keefe were at the end of their relationship, or some type of proof he can use to show that he was disgusted with him, which once again, in a lot of ways, I think we've already heard that testimony. Now, Hank knows he can't outright ask for this information for that reason. He's not stupid. But if you think this proves a lack of fairness in this case, check this out before I get to the good news. Hank wants a re-examination of Karen Read's Lexus SUV. Specifically, he wants to reassemble and test the SUV's telematics system because according to the newly hired expert, Shannon Burgess, significant data was likely not acquired during the review called a chip-off. Now, I noticed in that statement he used the word likely and didn't say is. And I guess cell phone data and GPS signals aren't the end-all be-all, which ties to some of my concern in the Idaho 4 case. But let's be fair, because if evidence is available or it's missing, then we need it. Not just from Karen Read, but maybe finding those phones would be nice if there was some way to locate the dog. Or maybe if they could locate that flooring. Evidence is evidence. The evidence points to the truth. The truth matters more than feelings. It's not that hard. I mean, Lord knows, Canton, Norfolk, and MSP aren't going to climb down from their ivory tower or their local watering hole to retrieve this information. In fact, the only way they'll get this information is if the FBI hands it to them on a silver platter. Very much like the Sandra Birchmore case. But who are we kidding here? Brennan wrote, this evidence may be exculpatory or inculpatory, which is honestly a load of crap in my opinion, allegedly speaking. Does anyone actually think the prosecution is going to pay for an expert to prove their case wrong? I would personally guess, and this is just a guess, that Brennan sent out multiple feelers to a lot of experts, seeing who could use this data to prove his case. And the person who said they would be able to prove his case is the one who gets to be the expert. And since new experts aren't cheap, let's talk about the cost. You expect me to believe this possible missing evidence is so crucial, but the state went years not having it and didn't seem to care to go get it. I mean, honestly, I'm not buying it, but I will buy this being another intentional cost for Karen Read, because this stuff's going to be sent to Texas for reassembly and testing, which means Karen Read's defense will have to find and pay an expert to go down to Texas and supervise this reassembly and testing, then review what that testing showed. Or take the state's word on everything, which doesn't seem likely. But let's get to the good news. Now, I don't always agree with the stances the ACLU makes, but rights are rights, and they fight for rights. And they're fighting for Karen Read's rights, saying Judge Bev erred in not holding an evidentiary hearing to determine whether or not the jurors reached a verdict. Now, I fully understand the positions some of y'all are making, saying the defense didn't ask for a poll. That's a valid point. But no one did. And no one knew this new information. And this new filing aligns with what I said in the beginning. I don't honestly care if you're tired. I don't care about anyone's dinner reservation. I don't care if you made plans that afternoon. I care about finding out the facts. I care about justice. I care about a fair trial and understanding what happened to John O'Keefe, which is way more important than you being tired. A simple closed-door hearing with everyone present could have resolved this issue months ago. Now you can feel free to disagree, but to me this filing offers validity to what I said should happen. It validates the defense's stance, and it could carry some weight in the Supreme Court's decision. Look at it like this. A one-day hearing could potentially shave weeks off of this trial, saving the taxpayers who knows how much. So honestly, what was the problem with that? What's the problem here? What are we scared to find out? To me, I feel like nothing has changed or will change in terms of fairness and transparency. If you feel differently, let me know down in the comments below. Y'all be safe now.